this decision overturning the Chevron deference doctrine wasn't the judiciary aggrandizing onto itself power that Congress did not foresee or grant. It was actually vindicating the congressional decision to have the judges figure out what the law means. One of the nice things about being Chief Justice is that you get to, if you're in the majority, if the chief is in the majority, he gets to pick who writes the decision. If he's not in the majority, the most senior, I think the rule is the most senior justice in the majority otherwise picks. So if the chief isn't in the majority, the senior justice who is in the majority picks. Otherwise, the chief picks. And of course, he picked himself to write that important immunity decision. And he also picked himself to write what is going to be, I think, a significant decision in the in our republic in terms of the rule of law, the powers of the administrative state, again, and the right to govern ourselves. I think I had a tweet about this decision, this so-called Chevron-related decision that just came down at the end of the Supreme Court's term. Let's go to that tweet. It was a tweet about the, well, anyway, I don't think we have it. But I described how this decision upended this precedent that was at odds with what everyone understands to be constitutional government. And previously, the courts had been deferential under the so-called Chevron precedent to agencies when they made decisions in applying law written by Congress. Now, it's one thing if the Congress tells an agency, this is the law. You know, you can't. I don't know what would be a good example of it. Anyone driving over 50 miles an hour needs to be fined. I don't know if that's. But if the law, and that's pretty easy, right? But what if the law said anyone driving too fast needs to be fined? That's probably not a perfect analogy, but it's pretty close. Who should decide what's too fast? The bureaucrats or judges? And the Supreme Court said the law requires judges to figure out what the law means. And in that case, if it's too vague, they kick it back. Or if they think they understand what they mean, they apply it as they understand it. And this is how Chief Justice Roberts, who again assigned himself this historic decision as well for the majority, describes the so-called Chevron deference. Our Chevron doctrine requires courts to use a two-step framework to interpret statutes administered by federal agencies. After determining that a case satisfies the various preconditions we have set for Chevron to apply, a reviewing court must first assess whether Congress has directly spoken to the precise questions at issue. If and only if congressional intent is clear, that is the end of the inquiry. But if a court determines that the statute is silent or ambiguous with respect to the specific issue at hand, the court must, at Chevron's second step, defer to the agency's interpretation if it is based on a permissible construction of the statute. The reviewing courts in each of the cases before us applied Chevron framework to resolve in favor of the government challenges to the same agency rule. And so this decision overturned Chevron, overturned that precedent, because they said Chevron doesn't work. So what's been happening, and you've seen it generally through the presidential administrations, you have one administration come in and say, well, the law allows us to do X. The next administration comes in and then reverses it and says no. And so it restricts it or sometimes even expands it one way or the other, depending on the administration. And the court's saying that's no way to run a railroad. That's not what our Constitution wants our government to operate as or under. That sort of feckless, bureaucratic, arbitrary and capricious and political action in areas of ambiguity. We don't allow bureaucrats just to figure out what the law is. That's the role of the judiciary. I mean, essentially, under Chevron, the executive branch was allowed to be the legislature, the executive, obviously, and the judiciary all at once. And the court kind of ceded their judicial function to the bureaucracies under the Chevron deference doctrine. And Chief Justice Roberts explains kind of the background as to why this was so outside what the law requires, not only constitutionally, but what federal law required the court to do in terms of handling administrative action. Because back in 1946, Congress passed a historic law called the Administrative Procedures Act that describes in detail how administrative law or how administrative agencies are supposed to apply the law and operate, and what the court's role is in adjudicating issues related to the administrative determinations as it relates to legislation and, as the law says, administrative procedures. Chief Justice Roberts on page 13, for those of you following along. Congress in 1946 enacted the APA, the Administrative Procedures Act, as, quote, a check upon administrators whose zeal might otherwise have carried them to excess, not contemplated in legislation creating their offices. It was a culmination of a comprehensive rethinking of the place of administrative agencies in a regime of separate and divided powers. In addition to prescribing procedures for agency action, the APA delineates the basic contours of judicial review of such action. As relevant here, Section 706 directs that to the extent necessary to decision and when presented, the reviewing court shall decide all relevant questions of law, interpret constitutional statutory provisions, and determine the meaning of or applicability of the terms of an agency action. It further requires courts to hold unlawful and set aside agency action, findings, and conclusions found to be not in accordance with law. The APA thus codifies for agency cases the unremarkable yet elemental proposition reflected by judicial practice dating back to Marbury, which is Marbury versus Madison, the case that established judicial power or described it for the first time in American history at the Supreme Court level, that courts decide legal questions by applying their own judgment. Now, you heard me describe the Chevron deference, right? Can't you see just in that analysis how Chevron deference is completely at odds with the federal law? So this wasn't like this decision overturning the Chevron deference doctrine wasn't the judiciary aggrandizing onto itself power that Congress did not foresee or grant. It was actually vindicating the congressional decision to have the judges figure out what the law means. So I don't understand what any of the complaints are about. Let me see if I highlighted anything else here worth reading. I tell you, it doesn't get any more clear-cut than that. You know, and the court spends a lot of time, and I encourage you to read all the decisions. Justice Gorsuch has an excellent concurring opinion kind of describing this, frankly, the dishonesty of those complaining about the decision to overturn Chevron. But it's a major development for those of us concerned about the rule of law and your right to govern yourselves. I mean, do you want unelected bureaucrats just deciding what Congress wrote with no check by judges? They get to decide an ambiguous section of the law, and judges have no say of whether that is what the law actually means? Of course not. And the left is upset about this because they rely on Chevron deference to do things that the law doesn't allow them to do. They read a vague section of the law as an opportunity to expand government power in ways never contemplated by the underlying statute. We've seen that time and time again. And as Chief Justice Roberts goes through, and the other justices, and you can look at all sorts of commentary on Chevron. It's one of the most widely discussed decisions in the history of the court. Even the courts have kind of started to run away from Chevron in all sorts of other cases. I mean, this is just the final nail in the coffin on Chevron. I mean, for instance, the court has said there's a major questions doctrine, that when a statute authorizes certain government action, it doesn't follow that the federal government can do anything they want based on the statute. Like in the case of the laws related to the administration of student loans, it doesn't follow that Congress meant the president to have the ability to forgive $500 billion in debt. Major questions, to the degree there's an assignment of a major power to the president and his administration, it's got to be clear. And if it ain't clear, you can't do it. And Chevron reaffirms that. I mean, look at the Clean Air Act. I don't know if it's going to overturn the Clean Air Act. Chief Justice Roberts says that prior decisions based on Chevron deference, and I don't know enough about that famous Massachusetts case where the Clean Air Act was read to allow or even require the regulation of carbon dioxide because of climate change. It's not a pollutant in any sense of the word. So maybe, that's why the left is nervous, because a lot of their environmental regulations, which are always escalating, rely on Chevron deference. So the climate scam artists, those seeking to increase the powers of the deep state, they're all angry. They're all angry right now because they can't jail Trump the way they wanted. They can't trail conservatives the way they wanted because there are many other people protected by these immunity agreements. They can't harass corporations and the private sector the way they wanted as a result of the Chevron agreement, the Chevron decision. So good news. Now, was the court's term perfect? No. It punted on First Amendment censorship. It punted on the right to life in certain areas, kind of avoided the issue. And the decisions were all over the place, and it wasn't necessarily a left-right fight. It was even the right side of the court was divided on some of those issues. So it was far from a perfect, as far as I'm concerned, right? A perfect term for the court. But in terms of presidential immunity, in terms of Chevron deference, in terms of curtailing some of the abuses of the Justice Department, the court batted nearly 1,000. So good news for the Constitution and good news for the Republic. Thanks for watching. Don't forget to hit that subscribe button and like our video down below.